Alright, continuing Surface Transportation Board. Alright, part of 1180 of the Railroad Acquisition Control Merger with the Consolidation Projection from the Trackage Right with the Lease Field Procedure, Subpart 8, General Acquisition Procedure 1180, Scope of the Purpose 1180, General Policy Statement of the Merger with the Control of at least two Class Road 1 Railroad 1182, Type of the Transaction 1183, Definition 1184, Procedure 1185, Reserve 1186, Supporting Information 1187, the Market Analysis 1188, and Operational Data 1189, Financial Information 118010, Service Assurance Plans 118011, the Transnational or Other Information Requirements. Subpart B, Transfer Operations of Lines with the Railroad Reorganization 118020, Procedures. Alright, Subpart A, General Acquisitions 1180, Scope of the Purpose, General of the Regulation with the Subpart of the Information File with the Procedure of the File with the Control of the Merger, Acquisition, Leave of the Trackage, any of the Consolidation Transaction involving the more than one railroad initiated under Title 49 U.S. Standard Code 1132.3 with the Section 1182 separate for each transaction four types of major, significant, minor, and exempt. The informational requirements for the type of the transaction with it before an application is filed with the designation type of the action with it may be either clarified with a certain information required with the may be waived with the position with the board with the procedure with explained with 1184 with the required contents application are set out in 1186 with the general information support with the transaction 1187 the competitive with the market information 1188 operational information 1189 financial data 118010 service assurance plans 118011 the transnational other information requirements a major application must contain the information required in 1186A 1186B 1187A 1187B 1188A 1188B 1189 118010 118011 significant application must contain information required with 1186A with 1186C with 1187 A1187C, 1188B, with the minor application must contain the information required with 1186A, 1188C. Procedures include the time limit for the file requirements, participation requirement, the other man for the containment of 1184. All applications must comply with the board's general rules of the general applicability, Title 49 CFR 1100 through 1129. Otherwise specified by the regulation must be set with the Railroad Consolidation Procedures Waiver. We waive the application for the regulation contained with the subpart of the consolidation involved with the Kansas City Southern Railway Company and any other Class 1 railroads instead of the will apply with the regulation. Subpart A with the in effect with the July 11, 2001 contained with the Title 49 CFR 1000 through 1199. Edition revived on October 1st, 2000 unless now shown why such waiver should not be allowed. The interested party must file with the objection of the waiver within 10 days for the applicant pre-filing with a notification. See Title 49 CFR 1184B1. 1181, General Policy State with the merger of the control at least two Class 1 railroads. General, to meet the needs of the public and national defense, the Surface Transportation Board seeks to be balanced substantially with the position of the railroad industry. The board recognized with the railroad industry, include with the Class 2 with the Class 3 characters network competing complementary comments which of the term of the broader transportation infrastructure that embrace the national highways, waterway, and port, airport. For the board welcome the private sector for the initiatives and enhance the capability of the competitive of the transport infrastructure. Although the merged Class 1 railroad made advance for the nation's economic growth of the competition with the effect of the provision or of the more responsive transportation does not favor the consolidation, reducing the transportation alternative available to shippers unless the substantial demonstrable public benefit of the transaction cannot otherwise be achieved. The public benefits include improved service, enhanced competition, greater than economic efficiency. The board also would like to, with disfavor the consolidation over the controlling with it, even if it does not assume the full responsibility for the carrying out of the control care of the common carrier with the obligation to provide adequate service above the responsible demand. Consolidation criteria for the board with the consideration merger for the control of the least two Class 1 railroads governing with the two public interests and with the criteria with the Title 49 U.S. Standard Code 1132.4 and with the railway transportation policy set forth in Title 49 U.S. Standard Code 10101. In determining the public interest, the board must consider the various general goals of the effect of the competition carrier with the safety and efficiency, adequate service for the shippers, environmental safety, with the fair working with the condition with the employee with the board must ensure that they approve of the transaction would promote the competitive efficiency, reliable national rail system. Public interest and with the consideration, board believe the merger serve the public interest only with a substantial demonstration of the gain of the important public benefits for the improved safety, enhanced competition, greater economic efficiency, outweigh anti-competitive effects of the potential of the disruption, other merger-related harms. Although further consolidation, few remaining Class 1 railroads, Class 1 carriers could result in efficiency gain with improved service of the board believe that additional consolidation in the industry is likely to result in some of the anti-competitive effects, such as loss of geographical competition, increasing the difficult to remedy directly and proportionally, but additional consolidation could also result in sort of a disruption from the system and interrogation period. Accordingly, to the assurance balance in favor of the public interest merger, applications should include provisions enhance competition, both carriers and financing sound. The board is prepared to use the conditional authority and conditioning authority of the necessary in Title 49 U.S. Code 1132-4C, preserve and enhance competition. In addition, with evaluating the public interest of the board, will consider whether the benefits claimed of the applicant and with the relive of the means of the proposed consolidation. Board believe the other private sector of the initiative, as such as joint marketing agreement and interline partnership, that reduce the efficiency of the merger with the risking less potential harm to the public, and the potential benefits of eliminating the transaction cost of the barriers between the firm, increasing the productivity of the investment and enabling the carriers to lower cost of the economy scale with the scope of the distance of the merger with the general import of the public benefits, such as the improved service, the more competitive, the greater effect with the economic efficiency of the merger can strengthen the carrier with the financing of the operation to the extent that the merged carriers continue to operate with a competitive environment. Its new efficiencies would be shared with the shipper, with the consumer, with the publisher, with the consolidated carrier can benefit for the carrier with it able to increase the marketing opportunity to provide the better service of the merger transportation transaction will also improve the existing with the competition, provide new competitive opportunities such as enhanced competition. Competition will give it a substantial weight in our analysis. The application should make with a good effort to calculate the new net public benefits of the proposed merger would generate. The board will carefully evaluate the evidence to ensure that the applicant with the new incentive to exaggerate these projected benefits to the public of the board. Expect for the applicant to propose the additional measure the board might take into anticipated public benefit to materialize at the time manner. In this regard, the board recognizes that, however, the applicant requires the flexibility to adapt to changing the marketplace with the other circumstances. The inevitable that is approved may not necessarily be implemented precisely in the manner anticipated with the application. The applications will be held accountable, however, they do not reasonably lie below the charging circumstances to achieve the proposed merger benefits. 2. The perform harm. The board recognizes the consolidation of the improve of the cost of the benefits of the reduce the competition both directly and indirectly with the marketplace, include with the product market, with the geographical markets of the consolidation can also threaten essential service. The reliable rail network analysis of the impact will consider but are not limited to policies embedded with the antitrust law of the reduction of competition. Although the specific market railroads operate with a highly competitive environment with a vigorous intermodal competition from the motor water carriers, the mergers can deprive shippers of the effect of the opposition. Intermodal competition can be reduced with the two carriers serving the same original designations. Merger of the competition arrive at the shipper that boiled out and the transloading the plant sitting and producing shifting shows over the eliminated produce the two rails serving the overlapping area of the merger. Competition produced with the geographical area that can be also eliminated produced the merger, including end-to-end mergers. And the railroad combination, the entail of the risk of the merger carrier will require exploited increased market power. Applicants should propose the remedies mitigated the offset of the competitive harms. Applicants should also explain how they would minimize the preserve of the competition market options, such as those involving use of the major existing gateways built out of the buildings, or the opportunity to enter the contract one segment of the movement as the means of the gaining of the right separately with the purpose of the rate relief of the remainder of the movement. 2. Harm of the essential service. The board must ensure the essential freight with the passenger commuter rail service with the preserve of the wherever the feasible with the existing service essential for the efficient public need with the service of the adequate alternative of the transportation is not available. The board with the focus on the ability of the nation's transportation infrastructure to continue to provide support essential service. The merger should strengthen and not undermine the ability of the rail network to advise the nation's economic growth and competitiveness. Both domestically and internationally, the board will consider whether the projected shift of the traffic for the pattern with the undermine the ability of the various network line links to include with the Class 2, Class 3 railroad carriers, ports essential services, transaction services, transitional service problems experienced that show the significant services also the rising during the transition period with emerging firms that integrate with their operations even after the application of the extraordinary step of the avoid the disruption because of the service of the disruption harm to the public. The board in its determination of the public interest way with the likelihood of the transitional service problems in addition with the paragraph H of the section the board board will require the application to provide detailed service to assure that the plan with the application should explain how they cooperate with the carrier, overcoming the series of service of the disruption of their lines during the transitional period afterwards, enhanced of the competition, the offset of the home, but that would not otherwise be mitigated. The application should be explain how the transaction conditions would probably enhance the competition. Condition of the board with the broad of the authority, Title 49 U.S. Standard Code 1132-4, with the C, with the input of the condition, with the consolidation, include with the requirement with the investiture with the payroll track, with the granting, with the trackage rights, with the accessibility of the other facility of the board will condition, with the proof of the Class 1 combination, the mitigate with the offset of the home of the public interest, with the will carefully consider proposed applicants in this regard, but the board may impose the condition of the operatable, feasible, to produce for the net public benefits, whether not impose the condition undermine the defeat of the beneficial transaction by creating unreasonable operating, financial, other problems combined with the carrier of the conditionals are not generally not appropriate with the compensation of the parties may be the disadvantage of the decree for the competition board. Anticipation merger Class 1 rail carriers would likely create some of the anti-competitive effects that would make it be difficult to mitigate through the appropriate conditions of the transitional service to disrupt might temporarily negate any of the shipper's benefits of the officer of the potential harm, with improve the prospect of the proposal will be found within public interest for the applicant should propose the condition of the would be not simplify with the preserve of the enhance the competition for the board, seek to enhance the competitive position and waive the strength of the substantial rail networks as a whole, include as the portion of the network operated with the Class 2 and Class 3 carriers. Employee protection for the board is required to provide a fair arrangement with the protection of the rail employee with the applicant with the achievement of the consolidation board supports earlier the consolidation between the management and the various unions leaders and negotiated and implemented an agreement with the board strongly favors otherwise board respect for the sanctity of the collective bargaining agreement and will look to extreme disfavor the overriding of the collective bargaining agreements except to very limited extent with the necessary to carry out with the proof of the transaction. The board will review the negotiated error agreements and ensure the fair equitable treatment of the all effective employees. All negotiated agreement with the board will be provided with the protection level mandated law by Title 49 U.S. Standard Code 1132-6A, and unusual circumstances as are shown with a more stringent protection will be provided with ensure that the employees have a fair equitable arrangement. F. Environmental safety. With the National Environmental Policy of Title 42 U.S. Standard Code 4321, a 10 sequence of the National Environmental Policy Act that requires the board to take an environmental consideration count, railroad consolidation in case if they meet the responsibility of the National Environmental Protection Act, National Environmental Protection Policy Act related to the environmental laws. The board must consider the significant potential benefits of the advisory implement impacts, and if deciding whether to approve the transaction, deny the proposal, approve it with conditions, including the appropriate environmental mitigation conditions addressing concern of the rates of the parties, including federal, state, local government, and even for the board office of the environmental analysis, ensure the agency meets the responsibility of the National Environmental Policy Protection National Environmental Policy Act. The important regulation Title 49 CFR 1105 of the providing the board with the independent environmental review of the merger proposal of the program with the necessary environmental documentation of the OEA, focus of the potential environmental impact of the result of the merger related to the charge of the activity levels of the existing rail lines and the rail facility board, generally with the mitigate with these impact with the result of the directly with the approved transaction will not require that the mitigation of the existing conditions of the existing railroad operation. During the environmental law review of the process of the railroad applicant with the negotiated agreements will affect with the community, with include with the group of the community, with the intent either to stay with the local agent of the board encourages voluntary arrangement agreements with the national will become extremely helpful with the effect of addressing of the specific local or regional environmental safety concerns, including the sharing costs of the associated with the mitigating with the manager related environmental impacts. Generally, these privately negotiated solutions between the application of the railroad, some of all of the communities of the particular rail corridors, or the other appropriate and even more effective. In most cases, more far-reaching the environmental mitigation option of the board will impose the unilaterally, therefore, in which of the agreements submitted to the board generally will impose the necessary negotiated agreements as the condition to approve merger of these agreements generally will substitute with a specific local and site-specific environment mitigation with a community otherwise would be imposed in order to encourage to give the effect of the negotiated solution wherever the possible the opportunity to negotiate arrangement agreements will remain available throughout the oversight of the profit the place of local site-specific environment mitigation imposed by the agency. The board will require the complying with the term of the negotiated agreement submitted into during the oversight of the imposing appropriate with the environmental conditions to replace the local and site-specific mitigation previously imposed. 3. Applicants will be required to work with the Federal Railroad Administration with a case-by-case basis, formally a safety integration plan to ensure that safe operations are maintained throughout the merger of the implementation process. As part of the environmental review process, applications will require to safety integration plans and evidence about the potential block grade crossings as a result of the merger-related traffic and crew of operational changes. Oversight of this condition, approval of the major transaction, the board will establish formal oversight of the process for at least 5 years of the filing. The approval of the application will be required by the evidence to the board with no less than annual basis to show that the merger conditions imposed of the board will working as intended of the application with adherence to the various representation. All right. Made of the record during the course of the merger perceived that no unforeseen harms of the rise of the would require the board to alter existing merger conditions and impose the new ones for the merger benefit the projections accepted of the board realized timely fashion partial will be given the opportunity to comment with the application submission application will be given the opportunity to reply with the parties of the comments during the oversight period. The board will retain the jurisdiction and impose additional conditions to determine the necessary for the remedy of the offset of the adverse consequences of the underlying transaction. H. Service assurance and operational monitoring. The quality service of vital important for the according to the application that must file with the initial application the operational plan with the service assurance plan identifying with the precise step that would take the service ensure adequate service of the provided the imposed service of the plan must include the specific information set forth in 118010 with how the shipper connection with the railroad include class 2 and class 3 carriers and parts across the new system and that would affect the benefit of the proposed consolidation as part of this plan application will be required to provide such benchmarks for the describe the extent with which they have the enter the arrangement with the shipper's group with the compensate with the service of the failure of the established contingency plan that would be available to mitigate the anticipated service disruption. The board will conduct a significant post-approval of the operational monitoring to ensure the service levels after the merger are responsible adequate. The board will require the applicable applicants to establish problem resolution and specifically perceive the probable resolution to ensure that any unanticipated post-merger problems related to the service and any of the transportation matters, including the claim of the promptly address of the team, that should include the representative of all of the appropriate employee categories, all board invasion within shipment of the ship and the service council made up the shipment of the railroad passenger service, the representative of the board, parts, rail, labor, and other interested parties to provide ongoing forum for the discussion and implementation issues. Loss and damages claims handling. Shipper the short line with the freight line claim with the Title 49 CFR 1005. The joint with the major implementation shall file with the claim with the writing of the electronically merged with the carrier with the claimant should provide with the supporting documentation regarding the effect of the claimant and claim claimant specifically damage and the determinable amount incurred with the pursuant with the Title 49 Series Part 1005 of the merger. Carrier should acknowledge each of the claim with a 30 day with a successfully number each claim with 120 days with the carrier. The receiver of the claim of the merger carrier should respond to each of the claim by paying with the decline of varying the compromise of the settlement. The board will take notice of these claims of these disposition of the matters oversight during any annual oversight period with the merger. The carrier shall be reported the claims received, type of the disposition each of the period covered with the oversight of the which the shipper and short liners may also contract with the applicant specified remedies with respect to the claim's final injunction of the contract issues as well as unreserved claims will be remain in a manner for courts. 5. Service failure claims. The applicant must suggest the protocol handling the claims related with the failure provided with the reasonable service due to the merger implementation problems commitments to the submits all such claim with the arbitration or will be favored. Alternative rail services. When shippers within the connection railroads require the relief of the extended period with the inadequate service of the procedure, Title 49 CFR 1146 and 1147, that are available to the board to review the document with the service level to consider the shipper's proposal, alternative service relief of the avenue for the relief that have acquired or have already explored with the merger carrier in an effort to restore adequate services. All right. 1. Cumulative impacts crossover effect. With regard to the review and remaining Class 1 carrier of the railroad industry constitute the network of the competing of the complementary components for the board cannot evaluate the merits of the major transaction inside installation. The board must also consider the cumulative impact of the crossover effect likely to occur with the revival of the carrier of the react with the proposed combination. The board will expect to applicants to explain how additional Class 1 mergers will affect the eventual structure of the industry with the public interest. The application should be generally discuss the likely impact with the future mergers on the anticipated public benefits of their own merger proposal. The applicant will be expected to discuss whether or how they take type of the extent that any of the conditions imposed of the proposed merger would have the altered any of the new conditions imposed would improve the future considerations. All right, J. In conclusion with the carriers, the board will consider the requirement of the inclusion of any of the other carrier as a condition of approval only where there are no other reasonable alternative providing essential service facility fitting up operational within the new system. Inclusion that can be accomplished without endangering the operational financial successful of the new company. K. Transnational and other information issues. 1. All application must be submitted to the full system competitive analysis operating plan for incorporating any operations in Canada or Mexico from which we can determine the competitive service of the employee, safety, environmental impacts, perspective of the operation within the United States, explaining how the operation of the Federal Railroad Administration would be maintained with the address the potential impact of the operation within the United States of the operation event elsewhere. With the system application must further provide information concerning the restriction preference for the under foreign domestic law with the policy could affect with the commercial decision. Applicants must also address how the ownership of the restriction might affect the other public interest assessment. The board will consult the relevant official of the appropriate with the ensure the condition with imposed with approve the transaction with the consistent with the North American Free Trade Agreement with the other pertinent international agreements to which the United States is part of the additional board will cooperate with the Canada and Mexico agencies charged with the approval of the oversight of the proposed transnational railroad combinations. All right, your national defense. Rail mergers must track the ability of the United States military to rely on the rail transportation meet with the national defense needs. Applicant must discover the acts of the national defense ramifications of their proposed merger, and M. Public participation should fully develop the record of the effects of the proposed railroad consolidation. The board encourages the public participation from the federal, state, local government departments, agencies, affected shippers, carriers, rail laborers, other interested parties. 1182 type of the transaction. Transaction proposed in Title 49, 1132, 3 involving more than one common carrier of the railroad are 4 major types: major, significant, minor, exempt. A major transaction control of the merger involved with 2 more one-class railroads. A significant transaction with the transaction not involved with the control of the merger of 2 more Class 1 railroad of the regional of the national transportation. Significant as the phrase is used in Title 49, 1132, 5A2, and C with the transaction not involved with the controlling of the merger of 2 more than Class 1 railroads. Not significant indetermination could be made either. The transaction clearly will not have any anti-competitive effect. The anti-competitive effect of the transaction clearly outweigh the transaction anticipated with the required contribution from the public interest of the meeting the significant transportation needs. A transaction not involved with the control of the merger of the 2 more Class 1 railroads significantly need the determination clearly can be made. A minor transaction which would involve the 1 more railroad which is not major significant exempt the transaction. A transaction is exempt if it is with one of the 8 categories for the described in paragraph D1 through A of the board for time with the private the review with approval of these transactions not necessary to carry out the rail transportation policy of Title 49 U.S. Standard Code 10101 and is limited scope of the necessary to protect the ship of the market abuse the Title see Title 949 U.S. Standard Code 10502. Notice must be filed one of these class exemption of the procedure set forth in 1184 G. These class exemptions do not relieve the carrier of the statutory obligation to protect the interest of the employee. See Title 49 1052 G and 1132 6. The enumeration of the following the categories transaction exempt that does not include the carrier with the seeking exempt the specifically transaction not falling into the other categories. Acquisition of a line railroad which would constitute the major market extension of the board has found with the public conveyance even the necessity permit abandonment. Acquisition continues to control the non-connecting carrier of the one of the line. The railroad will not connect to each other and any of the railroads of the corporate family. The acquisition continues to control, but they're not part of the tier of the anticipation transaction with the name of the railroads, each of the other railroad with the corporate family of the transaction. 2, 3, the transaction does not involve the Class 1 carrier. 3. Transactions will corporate of the family do not result in the adversely chain with the service level. The significant operational change drive of the competitive balance of the carriers outside the corporate family. 4. The renewal leases any of the matter of the board have the previously authorized the transaction and only the extension of the time involved. 5. Joint projects involve the relocation of the line of the railroad which does not disrupt the surface of the shipper. And 6. Reincorporation with a different state. 7. Acquisition trackage right with the renewal trackage right with the rail carrier over the lines the operative with any of their carriers with the R1 based on the written agreement. The 2 with the not filed with the sought with the reasonable application for the rail consolidation proceeding. 8. Acquisition of the temporary track with the rights of the rail carrier over the lines to own and operative that any of the railroad carriers or that are 1 based on the written agreement. The 2 with the not filed with the sought with the representative of the application for the rail consideration proceeding. 3 for the overhead operation only enforced schedule of the expire with the specific date of not received 1 year after the fact with the date of the expiration. Operation contemplated by the exemption will not include the 1 year party over the May prior to the expiration of the period of the file with the record of the renewal temporary rights over the additional period of up to 1 year, and including the reason for the rail carriers acquiring temporary track of the rights and not seeking the authority from the board discontinuing the trackage right for the expiration date with the specifics specified under Title 49 CFR 1184 G2 3. All transactions under these rules will be subject to the applicable statutory labor protective conditions. Or 1183 Definition: application. The term applicant means for the party interested in initiating the transaction, but does not include the wholly of the own, directly, indirectly, subsidiary of the any applicant. For the subsidiary is not a rail carrier. Parties who are considered applicants for whom the information normally required by the applicant needs not to be submitted. The end of minor trackage right. The application of the transfer responsible application of the primary applicant. The applicant carriers. Term applicant carriers mean the applicant of the rail carrier operating with the United States, Canada, and Mexico, in which the applicant of the controlling interest all of the other rail carriers involved with the transaction become the service of the provider of the commonly controlled carriers can be import competitively aspect transaction with approval of the applicant for the carrier subject to the full range of all the or condition power of the carrier that involved with the applicant with the only with the virtue of the existing trackage right with the applicant but not applicant with the carriers. C. Major marketing extension. The major marketing extension transaction may be significantly increased for the compensation exchange service in the new market, expanding service within concurrently with the service of the market and other carrier with concurrently with the contract with the services of the market as part of the same. The transaction provides significantly more effective, more efficient, but effective with the competition service of the market with the presently preserved the criteria can be used to determine if the railroad proposing to provide with a competitive service the concurrently served area with include the one the creator of the short route, two the providing enhanced service compatibility speed, but not only the factor three the entering of the interchange of the market generating more than 5,000 cars per year or 5% of the applicant with the traffic filing of the applicant for the condition with the relief of the pending with the proceeding and 5 of the permitting with the carrier with the permit with the war with the competitive with extending the length of the Hall C Burlington Northern incorporated with the control of the merger St. Louis 354 Interstate Commerce Commission 616 617 and 1978. The petition for the clarification required by the board clarify the applicability of the aim of the part of the regulation particular situation explain the type of the material needed to comply with these regulations. E. Petition over the way with the request of the board with the dispense of the material required with the regulations acquired except for the material with the plate for the required with these regulations. Primary application of the proposal approved with the file under Title 49 1132-3, which begin with the new proceeding of the not proposed with any either condition with the alternative board approval of the any other pending application of the railroad. Any common carrier with the railroad is defined in the Title 49 CU United States Code 10-102, 5, and 6. Responsible application of the may be filed with the response to primary application for the sequence the affirmative with either the condition in lieu of the approval of the primary application. The responsible applications include inconsistent application inclusion application in any of their affirmative relief of the requires application petition with the notice of any of the filing with the submitted with the board as in the trackage right of the purchase construction operation pooling at a terminal operation with abandonments or other type of the proceedings not otherwise covered and for these covering is inconsistent with the conditions. Inconsistent application of the response of the application not otherwise covered with the board fee with the schedule of Title 49 CFR 1022 F 38 through 41 1084 D2 with these fees all of the representative of the application set forth in Title 49 CFR 1022 F. The transfer acquiring the cooperation for the control proceeding with the surviving the corporation. The surviving corporation and the merger of the resulting corporation and the consolidation lease and the lease. The lesser and the lease. The purchase of the acquisition of the grantor of the trackage rights, proceed with the transfer and the corporation acquired with the control, proceed with the merger corporation, the merger of the corporation for the consolidation with the consolidation, lesser of the lease, seller of the acquisition of the grantee of the trackage right with the trackage right proceeding. Alright, 1184, proceeding. Jump of the original with the 25 copies of all of the documents filed with the major proceed with the original 10 copies should be filed with the significant minor proceed with each part of the proceeding shall show the unique acronym of the four level of the lesser of the itself of the holding number of the each of the document filed with the proceed with the consecutively prefixed acronym in any document filed with the board will include the application for the pleading and the etc. shall be promptly with the furnished for the interested person on the request unless subject for the protective order any of the time the board may require the submission of additional copies of the name of the document previously filed with any of the party of the board proceeding with the pre-filing notification between 3 and 6 months prior to the proposed filing of the application for the major transaction, 2 to 4 months prior to the proposed filing of the application for the significant transaction. Application shall be filed with the board with the notice of the shall with the brief description of the transaction, indicate the year of the BU for the impact with analysis, indicate the approximate filing date of the application, indicate whether the transaction major significant. The board will publish the notice of the Federal Register within 30 days of the receipt of the applicant. The notice of the publication shall contain the brief description of the transaction for the year of the U to impose the impact with the analysis of the appropriate approximate fill date with the determination for the transaction major significant minor and statement additional information must be filed with the applicant in order to applicant to be considered complete. The pre-filing with the notice must be amended to indicate the change of the anticipated filing date. With the pre-filing notice notification, following notice and intent with the required with the paragraph B1 of the section applicants must file with the proposed procedural schedule with an additional proceeding involved with the eve of the major transaction. If the transaction published for the Federal Register, not soliciting the comments of proposed with the procedural schedule with after the review any of the comments of the response, issue procedural schedule governing of the course of the proceeding. The proposed draft protect protective order, the board will issue each of the proceeding which subject to the order of the request of the appropriate protective order. 3. A statement of the way bill for the availability of the major transaction application must indicate the practical after the issuing of the protective order that will make it 100% of the traffic table available to subject of the terms of the protective order to ensure that the party with the written request of the applicant may require, if the requesting party itself or the railroad applicant for the bill may make the 100% of the traffic table available to the party only if they agree with the written request to make its own 100% of the traffic table available to the applicant subject to the terms of the protective order which receive the action for the applicant table the 4. Applicant may also propose the voting of the trust of the stage for the later stage that may come with the necessary of the proceeding involved in the age for transaction application contempt contemplating use of the voting trust must explain how the trust would be insulated them unlawful control violation from the proposed use of the trust of the contact with the impending with the controlling application would be consistent with the public interest for the following with a brief period public comment with a reply by the applicant for the board will issue the decision for determining whether the applicant may establish and use the trust applicant with the fees for the fees for filing with the applicant petition for the notice of the honor of these procedures set forth in Title 49 CFR 1002-2 following requirements filing requirements. Original of the applicant should be signed with the ink of the BI applicant with the individual all partner for the partnership with the corporation, association, or other similar organization by its president or such for the other executive officer have the knowledge of the man with the contained with the duly designated with the purpose for the applicant with the application shall be made with the honor of the oath and shall contain the appropriate certification of the corporation secretary with the showing of the affiliate with the duly authorized to verify the filing of the applicant with any person controlling with the applicant shall be also assigned with the applicant shall be filed with the chief section of the administrator of the office of the proceedings of the Transportation Board, Washington D.C. 204230001. Each of the copies of the application with the form and all the respective of the original shall be completed, self-exempt with the signature with the copies of the may be stamped and typed with the notary with the seal of the may be emitted and likely and with a certified copy of the documents for the field of the application conform with the copies of the showing the certification stamp with the type of the written will be sufficient to accompany with the additional copies of the applicant with the 4. All applicants required with the file with the board served done with the designated of the person include with the exhibited with the except for the otherwise specifically noted the information of the documents for the may be incorporated the reference for the applicant with however the documents must have the file with the board within 3 years prior to the following of the application. The information must be of the date of the applicant prepared with the supply with the copies of the information for the person specifically regarding the applicant should submit the additional information support for the applicant for the board may require applicant may file with concurrently with the directly related application to the seek with the authority to construct for the abandoned railway lines over the terminal operation acquiring with the trackage rights etc. The application should contain the certified service of the indicating all persons designated 1184 C5 have been served with a copy of the application for the major and significant transaction and the response of the application that does this direct testimony of the applicant with the form of the verified statement that shall be filed and served to each for the applicant. The applicant with all the exhibits shall be considered for the evidence of the record upon acceptance any of the portion of application exhibit that may be remain subject for the motion with the strike with the however no motion need that may have the applicant with the exhibit to the admitted with the evidentiary action with the designated with the oral evidentiary record with the major of the significant transaction designated oral hearing presiding administrative law judge shall have the discretion of the extraordinary circumstance to allow with the presentation of the oral written documentation direct testimony not previously submitted with the application. Service of the application shall serve with a confirmed copy of the application and files under the procedure of the first class mail upon the governor executive officer of the public service of the commission with the Department of Transportation of each of the state in which any of the property of the applicant with the areas involved with the proposed transaction situated. The Secretary of the United States with the State of the Department of Transportation Office Chief of the Federal Railroad Administration 1200 New Jersey Avenue Southeast Washington D.C. 20590. Attorney General of the United States. The Federal Trade Commission, and the major and significant transaction, all personnel requesting copy of the pre-filing notice of the published Federal Register for the applicant format with the application shall be the same sequence and the information requested with these procedures shall be numbered with the corresponding with the number in the procedures. 2. If the any of the material required for the applicant with the language itself is being played with the appendix should be with the done with the appendix the application to be tabulated with the cross-reference index exists, either locating with the referring to the information in the appendix shall be in the same sequence of the information required with these procedures with the certain information required with the applicant with the done applicable to provide explanation. Application shall be bound, but they may be bound with more than one volume. When the applicant is more than one volume, in the cover each of the volumes shall be this different color. These pages in each of the volumes shall begin with one of the sequential numbered. 3. The board office of the proceed with the provide informal opinion for the interpretation with the not binding with the board regarding the format of the information to be included with the application. And all filing services with the other requirements of these procedures must be complied with the filing applicants and with a copy of the application of the board may be marked with the red consolidation application Railroad consolidation application on the transmittal envelope of the package. The application should conform with the typographical specification of the 1104.2 of the information data required by the applicant with the consolidated with the information data require affiliated appropriate application carrier that accept the rejection and application of the board shall accept the complete with the application no later than 30 days after the application is filed with the board, publishing notice of the Federal Register. A complete application that contains the information of all of the applicant carriers required with these procedures, except for the modified with the advance waiver of the publication, indicate the applicable time limit, the process for the time application for the time limit, the Title 49 U.S. Standard Code 1132.5b, major transaction Title 49 U.S. Standard Code 1132.5c, with a significant transaction Title 49 U.S. Standard Code 1132.5d for minor transaction. The board shall reject incoming application by serving the decision no later than 30 days after the application is filed with the board with the decision, explain specifically why the applicant with incomplete the revised application must be submitted, the incorporating portion of the prior application, the reference submission, refiling the application should be considered de novo filing. The purpose of the competition with the time period for the provided the resubmitted the application, the accepted with incomplete. The application presented with the prima facie case for the application failed to do the meet the burden of the proof that they must not present with the prima facie case either one by disclosing the facts of even if the construed in more favorable with the light within sufficient to support the finding of the proposal to consistent with the public interest with one or by two disclosing the fact that the affirmative that demonstrated that the proposal is not in public interest. See railroad consolidation procedures 363 Interstate Commerce 767 1980. Responsive application. No response to the application should be permitted with the major and minor in transaction. An inconsistent application will be classified major, significant major transaction provided 1182A through C with the inconsistent application with the V with the type of the transaction involved with the C Title 49 CFR 2F 38 through 41. The V any other type of the responsible action with the G with a particular type of the proceeding set forth in Title 49 CFR 1002 F. The respective application filed with the except for the consideration automatically consolidation primary applicant with the consideration of evidentiary proceeding. The board will make order of oral public hearing with a hearing of the written submissions. Any other kind of the evidentiary proceeding with the determination generally made with the basis of the needs indicated with the written comments. Evidentiary proceeding will be complete with 1 year after the primary application except for the major transaction with 180 days. Significant transaction with 105 days. Minor transaction. A final decision primary application on all consolidation with the cases will be issued within 90 days of the conclusion. Evidentiary proceeding with a major conclusion transaction within 90 days. Significant transaction within 45 days. The minor transaction. Secondary transportation may propose purpose for the no modification of any of the transaction will have standing with the peer before the board support with any of the proposed modification. F. Waiver and the clarification on the petition with the perspective the applicant for the board may waive the clarify with the portion of each procedure of the petition. To waive all of the procedure will not be entertained. 2. Accept the otherwise provided within procedural schedule adopted the board and in particular proceed with the petition of the waiver. The clarification must be at least 45 days before applicant is filed. No reply for the petition waiver the permit except for the proceeding involved with the same permit the relay with the transaction pending before of the reply with the permit of the petition is served with the first class mail and all parties pending with the proceeding will apply due to 10 days to serve with the reply with the petition clarification shall be permitted within 10 days of the petition following on the waiver of the clarification granted with the applicant with the proceeding shall apply with any other part of the proceeding unless otherwise indicated. All petitions over the waiver clarification must specify the section of the waiver of the clarification itself with the give the specific reason of each of the waiver of the clarification necessary. Notice the exemption qualified for the exemption under section 1182D. The railroad must file with a verified notice for the transaction within the board at least 30 days before the transaction is consummated, indicating proposed consummation date before the notice of the railroad shall obtain the docket number of the board section of the administrative office of the proceeding. The notice shall contain the information over the required 1186A1 through 3, A56, A7, 2, indicated the level of protection imposed by the board shall publish the notice of the Federal Register within 16 days of the filing of the notice of exemption. Publication indicated labor protection required if the notice of the exemption contains false or the misleading information that is brought with the board of the detention. The board shall summarily revoke the exemption with the carrier that require the divestiture. The filing of the petition revoked with Title 49 U.S. Standard Code 1052 with the D with the does not state with the effect of the exemption. State with the petition must be filed at least 7 days before the exemption becomes in effect. 4 other exemptions that may be relevant and proposed with the provisions and codified in Title 49 CFR 1150 subpart D with the governing transaction Title 49 U.S. Standard Code 1091. To qualify the exemption under 1182 D7, the acquisition renewal of the trackage rights agreement additional with the notice for the railroad must file a caption summary suitable for the publication Federal Register. The caption summary must be in the following terms. Serve the transportation notice of the exemption financial document trackage rights 2, 2, and 3, 4 trackage rights of the one between 4 1 between 5 of the trackage rights effective on 6 of the notice was filed with 1182 D7 of the petition for the revoke of the exemption of Title 49 U.S. Area Code 1052D with the may be filed at any time of the following with the petition revoked at any not state with the transaction date of the board by the board insert the name of the director office of proceeding the following key items of the information symbolized within the summary, the name of the tenant railroad, the name of the landlord and railroad. If an agreement has entered the U that has agreed with the agreement that has been reached, but it has not entered the will agree with the indicate whether the overhead local of the trackage right, whether involved with the describe of the trackage right, state of the day of the trackage right with agreement that proposed with the consummated. 2. The qualifying exemption under 1182D8 with the acquisition of temporary trackage right with addition with the notice the railroad must file with a caption summary suitable for the publication of the Federal Register. Caption summary must be the following: for the transportation notice with the exemption, for the transportation filings and document number, temporary trackage rights 2 with the 2 and 3 with the grant overhead, temporary truck with the rights, the 1 between 4 with the temporary trackage rights with the effect with the 5 with the authorization expire on 6. Notice filed on 1182D8 D8 the revoke of the exemption of Title 49 U.S. Area Code 1052D may be filed at any time filing the petition revoke with the non-state with the transaction date board by board insert name the director or officer proceeding the filing key with identify with the information symbolized within summary name of the tenant railroad name of the landlord railroad. If the agreement has been entered for the youth agree with the agreement that has been the reach for the not entered the youth will agree with the describe of the temporary trackage right with the date with the temporary track of the right agreement and propose with the consummated with the day of the authorization will expire but not exceed 1 year from the day of the trackage rights will become effective. Some of the transaction, it may be subject to the environmental review pursuant to the board environmental rules of the Title 49 CFR 1105. The transaction imposing the interchange of the commons for the filing of the party must certify whether they not to propose the acquisition operation of rail line with involved with the provision of the agreement with the may limit for the future interchange with a third party connecting carrier, whether outright with the prohibition pen per car for the penalty with adjusting the purchase price for the rental and deposit for the economic inducement of the main interchange with comment made within such a provision agreement that exists for the following additional information must provide with the information paragraph of the G4, 1, B, D, and G of the section must be filed with the board under Title 49 CFR 1104 14A will be kept over the confidential will already without need of the following in any of the company motion with the protective order in Title 49 CFR 1104 14B. The existence of the provision agreement, the identification of the effect of the interchange point with the confidential completion of the version of the documentation containing addressing the provision for the agreement, a list of the shipper that currently with the heavy use of the line with the question within the last 2 years, the aggregated number of the carload shipper that was specified in the AG41C, the section originated with the terminated confidential. E, with the certification filing of the party provided notice for the proposed transaction, ownership of the commitment with the shipper identified with the paragraph G41C, with the F, the list of the third party railroad with the physically interchange with the line itself with the required lease. G, an estimate of the difference between the sale and the lease price with the without with the interchange commitment with the confidential. H, with the chain with the case with the option with the existing with the interchange with the commitment with the apparent with the case with the title. 2, with the obtainment of the information of the interchange commitment that used of the receiving for the board with the shipper or the other affected party may be granted access with the confidential documents following pursuant with 1184 G41 of the section following with the shipper going upon with the position or motion with the access with the confidential documents containing the explanation part of the need for the information appropriate to draft protective order with confidential undertake with the will and shipper the document with the kept confidential. 3, deadlines to reply with the motion with the access with the due with the 5 days of motion and filed. B, the boards will rule the motion active within 30 days if the motion is filed. With the C, the parties must produce the relevant documents 5 days for the receipt of the board's approve of the signed confidential agreement. H, official notice. The connection with any of the application requested to file with the relief done with the procedure of the boards may take of the official notice of any of the following information for the data will be presumed valid unless the discredited with any of the party relying on the information note of the officially with the shall list of the information with upon request of the party shall be the official note of the party material available to any of the party for each element of the relevance application and any subject to have the waive that should be accorded it. Annual State for the Transportation Form R1 report submitted with the rail carriers quarterly commodity statistics submitted with the rail carriers serve the transportation monthly labor statistics quarterly financial statement of the rail carriers all their other reports submitted with the State for the Transportation under oath. 6 annual 1% weigh bill sample. 7 the Federal Reserve Board production statistic. 8 AAR compilation of bad order ratio of the equipment that ownership of the repair with the statistic freight car order figures. Alright, 1180.05 reserve and 1180.86 supporting information. We're going to cut the tape there.